The information found in this video and related presentation is provided by the Retirement Research Foundation and is for educational and informational purposes only. Nothing in this video should be considered to be tax or investment advice. Welcome. Thanks for joining me here at the Retirement Research Foundation. I'm Daniel Rondberg, and with me is Ben Skinner from Taylor Skinner Law. Ben, so glad to have you here today. There's trusts and there's wills. Yeah, and everybody thinks they automatically need a trust or a will.
That's right.
What's the differences? And let's talk about those.
And there's even some other ways of doing estate planning that includes family limited partnerships. There's a lot of really complex ways for tax planning reasons that you might do different things. But 99% of our clientele fall into one of those two bases of planning, where you have a plan either based on a will or based on a trust. Now, a complete estate plan always includes powers of attorney for health and financial authority, and then also includes an end-of-life care document, most often called a living will. Sometimes you hear it called a DNR.
Okay.
But that's a complete estate plan that has either a will plus those three other documents, or a trust, which still would have a will, which is called a pour-over will, that just is a backup to the trust. And I can go back into why that's necessary later. But then I would always have those other three documents. So most everybody fits into one of those two plans. I get this all the time when people come in. They've been talking to their buddies around at the bar or whatever, and everybody thinks they need a trust. But there's lots and lots of people nowadays who don't need a trust, and it is not an issue of the size of their estate, because I've had lots of people that have very large, very very accomplished careers and great estates that still don't need a trust.
Wow. So
the modern trend across the country, but especially here in Arizona, has been to allow more and more property to be handled by beneficiary designations. That's like on your 401k or on your life insurance, you get to pick who is the beneficiary of that product, or if it's an annuity or whatever it may be.
Yeah.
Those beneficiary designations have been extended to do that now on a house. You can do that on a car. You can do that on bank accounts.
Wow.
And so for a lot of people, they can get by really well with if their equity is mostly in their house and in a 401k or IRA. For those people, they very often don't need a trust. Now, where I almost always encourage people to have a trust is when they have minor kids. Anybody that has a minor kid, or minor that they're, I guess all kids are minors. I want to clarify. But if they have a minor that they're dealing with, that they're planning for, they have to have a mechanism to be able to hold back the money in the estate until that person is no longer a minor. And most of the time, we advise people to even defer later than the age of 18. They maybe be 21 or 25 before you just turn them loose with money. And it's critical if they have minors that they have a trust. And the same is also true if you have a special needs child that may even be an adult.
Yeah, that's a good point.